My name's Coulson. I'm a senior associate at Wilson Gunn Patent and Trademark Attorneys. I'm a chartered UK and European patent attorney. My background is in chemistry. My experience covers a broad range of fields, including pharmaceuticals, medical devices, food and beverage compositions, polymer chemistry, and also mechanical devices. I joined Wilson Gunn back in several years' experience in drafting and prosecuting patent applications, together with acting for clients before the UK IPO in hearings and before the European Patent Office of opposition divisions and boards of appeal. Today, I'm going to give you a brief overview of patents and then move on to the crux of the talk, which is going to be a discussion on opposition proceedings before the European Patent Office. In particular, I'm going to highlight some of the key considerations for succeeding in these opposition proceedings. For those joining live, there's a Q&A and also chat function through the Teams meeting. If you do have any questions, feel free to send these using either function and we can come on to those toward the end of the talk. Okay, so just a very quick overview of the various intellectual property rights. So there's numerous intellectual property rights, and these are split into two main categories. That is unregistered IP and registered IP. The focus of this talk today is going to be on patents, which, as you can see, is a form of registrable IP. So what are patents? Patents are an exclusive right which is granted for an invention. The invention must fulfill three main criteria, these being that the invention is new, which is also referred to as the invention being novel, and the invention must have an inventive step, and the invention must be capable of industrial application. The invention must also not fall under a category of being excluded from patent protection, such exclusions being mathematical methods, scientific theories, or methods of doing business. A patent gives the patent owner the right to exclude others from using the invention. Now, this includes excluding others from making, selling, offering to sell, keeping, and importing the patented invention. Patents are territorial rights, and so they have legal effect only in the country in which the patent application is granted. For example, if you are the owner of a UK patent, then you have patent rights in the UK, but not in any other country. So while this means that in the UK, you can stop others from making, selling, keeping, and importing your invention, you cannot stop them from carrying out these acts in any other territory. So a competitor will be able to manufacture and sell your product in the USA, for example. Patent protection lasts for 20 years from the date of filing the patent application. This is provided annual renewal fees are paid to the Patent Office for the duration of the patent's life. The 20-year period may be extendable for a further 5 years if the patent owner is granted a supplementary protection certificate. Now, this applies mainly to pharmaceutical and plant protection products and is aimed toward compensating for long regulatory approval processes which these products must go through before they can be sold. A patent is essentially a deal which is made between the patent owner and the Patent Office. In that deal, you agree to disclose how your invention works in return for an exclusive right to use that invention for up to 20 years. Now, touching briefly on what makes an invention patentable. So, to be patentable, an invention must be new or novel, which means that it does not form part of the prior art. Prior art is considered to be everything made available to the public before the filing date or the priority date of the patent application. Now, this includes any publication anywhere in the world and in any format. And importantly, prior art also includes your own disclosures. It's a common misconception that with prior art, that a disclosure made by a patent owner cannot be used against them to invalidate their patent application. This is incorrect. Even your own disclosures made before the filing or priority date of the patent application can be used against the validity of your patent application. This is why it's critical to not publicly disclose your invention before filing a patent application for it. This includes not publishing research papers or pitching your invention to potential investors before filing the patent application. Now, if you have no other choice but to disclose your invention, for example, to a potential investor, then you must get them to sign a non-disclosure agreement before meeting with them. Regarding inventive step, an inventive step is a non-obvious modification over the prior art. To assess whether your invention has an inventive step, a patent examiner will look at the most relevant piece of prior art, so the prior art which is most similar to your invention, and identify the difference between this prior art and your invention. And they will then consider whether this difference would have been obvious to a person skilled in the relevant technical field. If the difference is obvious, then there's no inventive step. An inventive step is more likely to be acknowledged if the feature which distinguishes your invention from the prior art provides an unexpected technical effect or advantage over the prior art. Now moving on to the value of patents. Now there are plenty of reasons why a patent would add value to your business. For example, a patent can protect a technology which is the result of years of hard work and expenditure in your R&D department, or the result of your own inventive skill. Protection of this technology can also deter competitors from moving into the same technological area as your patented invention. A patent also allows you to enforce patent rights against your competitors to prevent or restrict their operations. Patents are also highly attractive to investors. A patent indicates innovation and the moving forward of a particular area of technology. It indicates growth and a willingness to try new things to improve your business. A patent is also a business asset which can be assigned or licensed. Advantageously, you can license a patent in exchange for a regular royalty payment, in addition to any initial licensing fee. And finally, if you're working with third parties, a patent can help define who owns what in a joint venture. When filing a patent application, you need to state who the inventors are of the disclosed technology. This sets out clearly, by way of a formal document, who worked on certain inventions, and this can prevent any issues further down the line. For example, members of the third party claiming that they had input or influence on a particular invention. So what makes a good patent application? A good patent application must meet your commercial aims. It must be focused on technology important to your business, which you wish to exploit, and which you want to exclude your competitors from exploiting. While there are reasons for filing a patent application directed to technology which you are not looking to exploit, for example, to act as a deterrent to third parties, it is more likely that you will find better value in a patent application which is directed to the key products and processes of your business. A good patent should also be enforceable. This means that the patent application is directed to a technology such that the patent application will result in a granted patent, which you can then enforce against your competitors. To obtain an enforceable patent, there are some sensible steps you can take even before filing a patent application. For example, conducting a search for relevant prior art. This will provide you with an overview of the publicly disclosed technology which could be cited against your patent application by a patent examiner. Provided you believe your invention to be novel and inventive over the most relevant prior art documents, then it would seem sensible to continue with drafting and filing a patent application. You should enlist the assistance of an experienced patent attorney, such as those at Coulson, who will be able to draft a good patent application which is right from the start. This may include the application including any relevant test data, which demonstrates that the invention has an unexpected technical effect compared with relevant prior art, and also ensuring that the invention is sufficiently disclosed within the application. The claims of a patent application define the scope of the protection sought. The claims define your invention in terms of a list of features which are found in your invention. Now, a good patent application will ensure that your claims are framed to catch potential infringements, while also covering your commercial product or processes. Typically, the broader the scope of the claims, the better, as this will capture more potential infringements. However, this will mean that there is likely to be more prior art considered relevant of the invention. So it is important to strike a balance between the claims being too narrow, but also too broad. So now moving on to opposition proceedings. Brief overview of EPO opposition proceedings. So opposition proceedings before the European Patent Office, or EPO, are the legal process which allows anyone to challenge the validity of a granted European patent in a single action in all of the territories in which the patent is in force. The validity of the EPO patent can be challenged on the basis of a lack of novelty, lack of inventive step, lack of industrial applicability, insufficiency, and/or added subject matter. Now, if you wish to file an EPO opposition, so that's an opposition against a granted European patent, the opposition proceedings must be initiated within 9 months of the date of grant of the EPO patent which you wish to oppose. This includes filing a notice of opposition and paying the official opposition fee, which at the minute I believe is around 800 to 900 euros. When filing the opposition, as far as possible, an opponent should include all of the evidence and arguments that they wish to rely on during the course of the opposition proceedings in their notice of opposition. Now, this includes setting out each of the grounds of opposition on which the opponent seeks revocation of the European patent and the extent to which the opponent desires revocation of the patent. The majority of the EPO opposition process is in the form of written submissions between the opponent, which is the party who files the opposition, and the patent owner and the EPO's opposition division. After an opposition has been filed, the patent owner will be afforded the opportunity to respond to any oppositions, including filing limitations to the claims during a 4-month window set by the European Patent Office. The issue a summons to oral proceedings, which sets out a proposed date for the oral proceedings and a final deadline for written submissions by the opponents and the patent owner. This summons to oral proceedings is accompanied by a preliminary, non-binding opinion, which sets out the opposition division's view as to the merits of each party's case and the state of the patent, together with any auxiliary requests, which are generally in the form of claim limitations, in view of the objections raised by the opponents. The final deadline for written submissions is usually 2 months before the date of the oral proceedings. This written submissions deadline is the final opportunity for both parties, so that's the patent owner and the opponents, to file arguments and amendments to their case. Submissions made after this date will only be admitted in proceedings at the discretion of the opposition division based on prima facie allowability criteria. The oral proceedings are typically held by video conference and last only 1 day. On rare occasions, they may last 2 days. A verbal decision is handed down at the end of the proceedings, and this is formalised in writing with reasoning, generally 1, 2 or 3 months after the date of the oral proceedings. The decision of the EPO can be appealed, and the appeal is made to the EPO Boards of Appeal. All opposition proceedings, are open to the public. So what are the advantages of an EPO opposition? Well, the advantage of a successful EPO opposition is that it may result in the complete revocation, or simply put, cancellation of a competitor's patent in all of the states or territories covered by the patent, therefore protecting your freedom to operate. If complete revocation of the patent is not achieved in the opposition proceedings, the patent owner may be forced to limit or amend the claims of the patent to an extent that the patent no longer covers the product or process, therefore also protecting your freedom to operate. As with revocation, limitation of the patent is also effective in all of the states or territories covered by the patent. On the face of it, an EPO opposition may be considered an expensive process. The filing of an opposition involves submitting documentary evidence, possibly also with expert testimonies and witness statements. The evidence will need to support every fact which is alleged in the opposition, and so gathering evidence is a lengthy process and can therefore be considered expensive relative to other actions taken when drafting and prosecuting a patent application. However, it's important to note that in contrast to other possible revocation actions in Europe, such as national invalidity actions or UPC revocation, the EPO opposition process offers a relatively cost-effective way of opposing a granted patent, not least because the official fees payable to the EPO for an opposition procedure are significantly lower than the court fees due when bringing a UPC revocation action, and that will be discussed later on. Also, the opposition process is a simple, streamlined process, and practice is well tested, in particular compared to the recently introduced UPC revocation process. An opposition of the EPO is therefore a cost-effective way to address an infringement risk in a single action across multiple markets. However, there is a balance to be met. The advantages of an EPO opposition must be weighed up against the possibility of choosing to engage in national litigation, i.e., attempting to invalidate a European patent in one or more of the states in which it is in force before a national court of that state, and/or a Unified Patent Court UPC revocation action. Bringing us on to the disadvantages of an EPO opposition. There is a limited window of 9 months from the date of grant of the EPO patent during which an opposition must be filed. If this window is missed, the opportunity to file an opposition is also missed. Moreover, EPO opposition proceedings are notoriously long. It typically takes between 18 months and 2 years from the filing of an opposition for an opposition hearing to take place. A decision on the case will be provided at this opposition hearing, which is also known as the oral proceedings. However, if one or more of the parties to the opposition proceedings decide to appeal the decision, the pertinent points of the case are heard again, but this time before a Board of Appeal of the European Patent Office. As with opposition proceedings, appeal proceedings culminate in a hearing in which a final decision on the matter will be provided. However, the appeal hearing may not be for around a further 2 years after the initial opposition decision was given, therefore resulting in a decision on the matter not being provided for around 3 to 4 years after the opposition was filed. For European patents which have not been opted out of the Unified Patent Court, or UPC, the UPC provides an alternative revocation route. This could be a favourable alternative, especially if the 9-month window for filing an opposition has already closed. Now, this is because the UPC revocation action may be brought any time after the grant of a European patent. UPC revocation actions typically have a much shorter time frame than an EPO opposition, and so a decision tends to be provided more quickly. However, UPC revocation actions are likely to be far more expensive than EPO oppositions. Court costs alone can be upward of €15,000. A further disadvantage of the UPC is that the UPC revocation action only affects the patent coverage in the countries where the UPC is in effect. It would not affect the patent coverage in any country not included within the UPC, for example, the UK and Spain. So consideration must be given to whether an EPO opposition is the correct choice to attack a patent. And if it is, it's critical that the right strategy is used when engaging the EPO opposition. Attacking or defending a patent may have a significant commercial impact on your business. And so for the rest of the talk, I'm going to share some experiences and expertise from myself and my colleagues, which we have amassed from attending EPO oppositions and appeals, including how best to robustly defend your patent against opposition and how to put you in the strongest position possible for opposing a competitor's patent. So, opposing a patent. When should an EPO opposition be filed? As previously mentioned, there's a 9-month window from the date of grant of the European patent in which an opposition may be filed. Consideration must be given as to whether the opposition is to be filed at the start of the 9-month period or later on, even on the final day of the period for filing the opposition. Now, this often depends on your opposition strategy and any relevant commercial objectives. Filing early on in the opposition period may be beneficial if multiple oppositions are expected to be filed. This will give you the best chance of being the first party to file an opposition and therefore being named opponent 1 in the proceedings. Beneficially, this means that it is likely that you will be the first opponent to present your case in the oral proceedings, which often subconsciously adds greater weight to your arguments as they are made before other parties submit their own arguments. However, in practice, the EPO's opposition division must allow each opponent a fair right to be heard. So whether you are opponent 1, 2, 3, or so on, you will each be given the same right to present your arguments. A pending opposition also has the effect of preventing any national infringement proceedings from taking place. As such, filing early on in the opposition period is also beneficial if you expect the European patent to be used to initiate national infringement proceedings. If the above are not real considerations for you, then you may wish to file an opposition later on during the opposition period. Advantageously, this means that you can maximise the possible time for gathering evidence, including witness statements and expert testimonies, and putting together a robust set of arguments. The time required for gathering evidence should not be underestimated. If you have only become aware of a relevant granted patent after it is granted, then you may have little choice but to file the opposition toward the end of the opposition period, so you have plenty of time to gather evidence and carry out any necessary experiments for supporting test data. So, moving on to why should you oppose a European patent? The potential value of a European patent should not be underestimated. The European patent acts as a powerful commercial tool which can be used to monopolise the patent owner's invention for up to 20 years from the date of filing the patent and in up to over 40 territories. It also allows you to exclude the patent owner's competitors from entering the same marketplace in that time and in those territories. So a granted European patent owned by your competitor may have a significant detrimental effect on your commercial aims and plans. This detrimental effect can be eradicated, or at least mitigated, by a single action of the EPO's opposition system. So now moving on to some strategic reasons why a European patent may be opposed. For example, in some instances, the scope of the claims of a European patent may not be clear. While such issues are often reasons for an examiner to not grant a patent, it is possible for a European patent to be granted, but it leaves you questioning whether your product or process falls within the claim scope or not. An opposition may force the patent owner to clarify the scope of the patent, for example, by amendment of the claims, or by filing a statement explicitly concerning the exact scope of the patent. Also, as previously mentioned, an EPO opposition may provide you with a basis to delay potential patent infringement proceedings before a national court. While an EPO opposition is a way to challenge the validity of a European patent across all jurisdictions in a single action, national courts maintain their own jurisdiction to decide on infringement and validity for their specific territory. In most cases, a national court will delay or stay infringement proceedings based on European patent when opposition proceedings are initiated against that European patent. However, this practice does differ depending on the national court where the infringement proceedings have been brought. For example, in the UK and Italy, the courts generally consider that a stay of national proceedings is the default option if a patent is being opposed at the EPO, unless there are strong reasons not to. In Germany, German courts are less likely to stay infringement proceedings unless they consider it highly likely that the patent will be revoked by the EPO. In terms of proceedings brought to the Unified Patent Court, the UPC Court of Appeal has indicated that a stay may be refused if a rapid decision from the EPO is not expected. The EPO has taken into consideration the desire of national courts and the UPC to be able to progress a pending infringement action. And so to avoid long delays where a national court is waiting for an EPO decision, the EPO has implemented a policy to accelerate opposition proceedings by issuing its communications more quickly. And that is if a national court or the UPC informs them of a pending infringement action. This acceleration can also be requested by a party to the opposition proceedings. An EPO opposition may also be filed for commercially tactical reasons. For example, to force a patent owner to consider negotiating commercial contracts between you and them. Such commercial contracts may be a license agreement in respect of the rights afforded by the European patent. If your opposition looks strong, this may force the patent owner's hand in offering you favourable terms under the license. Filing an opposition can be costly, but it may show to your competitors that you are aware of and actively monitoring their commercial activities and are willing to take legal action against them. Filing an opposition may be considered to be a sign of a company's strength, representing a proactive, strategic and high-stakes approach to market competition. An opposition may be used as a tool to show you are technically and legally competent, willing to defend your market share, and wanting to clear any obstacles to innovation and gain a competitive advantage. So, what to consider ahead of filing an opposition? It's important to carry out regular searching and monitoring of your competitors' patent filings, including ascertaining the status of their patent applications and reviewing correspondence from the patent examiner to get a feel for the likelihood of the patent application being granted. This will enable you to identify potential commercial issues, such as where your competitors may obtain patent protection, and formulate a strategy to mitigate these issues, and also capitalise on possible commercial opportunities. Again, for example, the opportunity to seek a license agreement from the patent owner. If a competitor's patent application is considered to be relevant to your commercial aims, it is sensible to take action while the application is still pending, so not yet granted. This will put yourself in the best possible position for filing an opposition. Such actions may include carrying out experiments to obtain relevant test data, which can be used to argue that the patent is not novel or inventive. Searching for prior art, which can be used as evidence of the lack of novelty or lack of inventive step of the patent, and searching for evidence of prior use of the invention claimed in the patent. And obtaining witness statements or expert testimonies to support your arguments against the validity of the patent, which you will submit in your opposition. Identifying at an early stage relevant European patent applications filed by your competitors will allow you more time to gather evidence and prepare a robust opposition case against the patent. So now some tips for opposing a patent. Tip number 1, be thorough. A granted European patent typically includes 1 or 2 independent claims which define the broadest scope of the protection sought by the patent, together with several dependent claims. The dependent claims typically include 1 or more features of the invention claimed in the independent claims, therefore further defining the invention, but also therefore being narrower in scope than the independent claims. A good opposition attacks each and every independent and dependent claim, the attacks being as comprehensive as possible and being well supported by evidence in the form of prior art, witness statements, expert testimonies, or evidence of prior use. When searching for prior art, it is important to consider the EPO prosecution file for the prior art cited by the examiner in search and examination reports. Just because the examiner has found a piece of prior art to not be particularly relevant doesn't mean it is, especially when looked at from the mind of an expert in the relevant technical field. It is also important to consider prior art mentioned in the patent itself. Often this prior art will be particularly relevant, possibly with the invention claimed in the patent differing from such prior art by only a small number of features. Search and examination reports issued against the prior art mentioned in the patent may also be relevant. Often, patents are filed as part of a patent family, which includes patents filed in overseas jurisdictions. The prosecution history and any post-grant proceedings of other patent applications in the patent family may also unearth relevant prior art which can be used in an opposition against the European patent. In particular, the prosecution history of any corresponding patent applications filed in the US may be useful due to the applicants having a duty to disclose all relevant prior art to the US patent examiner. Now, tip number 2 is the ground of added subject matter. In opposition, in some cases, the strongest attack is not one based on prior art or documentary evidence, but one which is made by arguing that the claims add subject matter beyond the content of the application as filed. If the claims have been amended during prosecution, take extra care to check whether the amendment is allowable. If the amendment is made by introducing a feature or a combination of features, which is not directly and unambiguously derivable from the applications filed, then the amendment may be considered open to an attack on the grounds of added subject matter. While arguments against the inventive step or sufficiency of a claim may be considered to have a subjective element to them, added matter tends to be more black and white. This means that an argument on the ground of added matter may therefore be more convincing before the EPO's opposition division. Priority claim. So, check whether any claim to priority which the patent makes is valid. For example, for a valid priority claim, the applicant of the European patent application must be the same as the applicant of the priority application or be a successor entitled to the applicant at the filing date of the European patent application. If this is not the case, the defect cannot be cured after filing and the priority claim will not be valid. Also, check for any new subject matter added to the European patent application when it was filed relative to the subject matter of the priority application. If there is new subject matter in the European application, this subject matter will not be entitled to the priority claim. If the European patent as a whole or part of it is not entitled to its priority claim, then the patent or the relevant part of it is not considered to have been filed on the date of filing the priority application, but instead is considered to have been filed on the date of filing the European patent application. This means that any prior art published between the once considered priority date and the filing date of the European patent application is actually pertinent to the claims of the European patent and can be used to attack the patent. Moving on to experimental evidence. So, particularly in cases relating to patents which concern chemical and biological inventions, an inventive step is often acknowledged when a claimed invention achieves a technical effect over the prior art. If you can show that the claimed invention provides nothing more than an alternate way of solving the same problem as that solved in the prior art, then it will strengthen your assertion that the claim lacks an inventive step. So, it's useful to perform experiments to test the technical effect of the claimed invention against the technical effect of the prior art. If the results show that the same technical effect is produced, then this provides a strong argument that the claimed invention lacks an inventive step. It is useful to conduct any experiments as early as possible so that the data obtained from those experiments can be filed with the opposition. Now, whether to hide your identity. So, as mentioned before, opposition proceedings are public. Written submissions filed by the opponents and the patent owner and documents issued by the European Patent Office are publicly available on the EPO's public patent register. This means that the identity of each opponent can be seen by anyone. If you wish to remain anonymous during the opposition proceedings, patent owner to know that you are opposing their patent, or because you may wish to maintain or build a commercial relationship with the patent owner, then there is the option of filing the opposition in the name of a straw man. This means asking another party to file the opposition on your behalf, so their name appears on the formal opposition documents and not yours. It is likely that if a patent owner knows you are opposing their patent, then the possibility of any future relationship being built is near zero. So, filing the opposition via a straw man is a good way of mitigating the risk of the patent owner finding out that you are behind the opposition. So now moving on to to discuss some strategy considerations when deciding whether to file an opposition. It's important to be clear about your commercial objectives, but be prepared to re-evaluate these during the opposition procedure. The opposition procedure can take up to around 2 years, even longer if the decision of the opposition division is appealed. In that time, your commercial aims and objectives may change. So it is set on in the opposition procedure so that your commercial aims do not deviate from what you are seeking to achieve by opposing the patent. An example may be if the patent owner's commercial interests lie in an area different to yours. You may then be able to seek a settlement which is a win-win for you and the patent owner. For example, by obtaining a license which will allow you to follow your commercial interests in return for not opposing the patent or withdrawing your opposition. You could also ask the patent owner to limit or amend the claims of its European patent in such a way so the patent no longer affects your commercial interests in return for not opposing the patent. It's important to note that a significant and unique set of rules exist for governing opposition and appeal procedures at the EPO. Recent changes to these rules considerably affect what arguments and evidence can be introduced into the opposition and appeal proceedings and at what stage. Without the assistance of an experienced European patent attorney, it is easy to overlook these rules and procedures and then risk losing an otherwise winnable case. So we always advise seeking the advice of a qualified European patent attorney when considering whether to oppose a European patent. And finally, some take-home points when looking to oppose a patent. And these are essentially a summary of what we've previously discussed. So, regularly monitoring pending European patent applications filed by your competitors to allow you to begin preparations for filing an opposition early. Unless there are commercial reasons not to, make use of the whole opposition period to conduct necessary experiments and build your catalogue of evidence against the European patent. File arguments and evidence against all of the claims of the patent to prevent the patent owner having an easy get-out by way of being able to amend the independent claims of the patent to the features of a dependent claim which you have not opposed. Consider all grounds of opposition when attacking a patent, including the ground of added subject matter. And don't lose sight of your own commercial aims and interests and how these relate to the opposition. Be prepared to seek a license or other commercial agreement in return for not following through with the opposition. And now moving on to defending your patent against an opposition. So we're now going to discuss some considerations which you should make when you're faced with someone filing an opposition against your European patent. So the first consideration is to be prepared from day one. There is no better defence than having a robust patent application. Often, successfully opposed patents never stand a chance of winning in an opposition because of the way the patent application was drafted. Drafting errors can lead to pitfalls in your patent application which cannot be overcome in an opposition, such that the patent is on a one-way street to failing at opposition. It's critical to ensure that your patent application is well drafted and that it includes a precise basis for possible fallback positions which are commercially valuable to your company. You don't want to get into a situation in which the opposition proceedings where you want to amend to a particular feature which would overcome the arguments put forward by the opponents and leave you with a commercially valuable patent, but you can't make this amendment because there is no basis to do so in the patent. You are then left in an all or nothing scenario where either one of your present claims survive or they fall and you have no commercially useful backup. So it's critical to draft your patent application correctly. Prosecuting your patent application. A patent attorney experienced in oppositions will also be aware of how careless prosecution of a patent application can leave the patent vulnerable in opposition. European patent law concerning amendments of patent applications is notoriously strict. Any amendments made during prosecution will be scrutinised during an opposition. An unallowable amendment made during prosecution is a common ground for revocation of a patent in opposition. So it is essential that any amendments made during prosecution have clear and unambiguous basis in the applications filed. There are also cases where an amendment is validly made in prosecution as there is clear basis for the subject matter of the amendment in the applications filed. But this subject matter is not in the priority document, and so the claim is not entitled to priority. As we previously discussed, this may bring into play prior art which was previously not of any concern. If that prior art is relevant to the amended claim, then this could lead to the patent being found to lack novelty or an inventive step. File a divisional if the patent application is of particular value. Filing a divisional application before the parent's patent is granted will provide a backup application in the event that the parent's patent is successfully opposed. A divisional patent application is a new patent application derived from a pending parent application, allowing applicants to pursue protection for additional, distinct inventions disclosed in the parent application. The divisional application can be used to seek patent protection for claims of a different scope or claim category compared to the parent. This may still be commercially advantageous to you and provide alternative arguments in support of patentability. It is possible to file third-party observations against a patent application before it is granted. If third-party observations are filed against your patent application, then this is a good indication that the patent application is of particular interest to a third party, and so may indicate that it is likely that an opposition will then be filed. This could indicate, again, that's a sensible decision to file a divisional application before the parent application is granted. So now some considerations as to the strategy for defending your patent. What do you need to win? So it's important to understand that you will need to successfully defend your patent against an opposition. Given that you may be faced with copious amounts of argumentation and evidence, you will need to be able to understand the strength of the opposition case you're faced with and what you need to defeat it. These include commercial objectives. It's sensible to review commercial objectives during the opposition procedure. If there is merit to the opposition, then this may have an impact on your commercial objectives, which may then need to be adjusted if it's likely that the opposition will succeed. Technical input. You will need to put together a case to defeat the opposition, and this may include seeking technical input from experts in the technical field. Evidence. Evidence in the form of experimental test data, witness statements, and documentary evidence may be used to defeat an opposition. These will take time to obtain and prepare, and so the sooner you begin to put together your evidence, the better. Consider any ongoing litigation or other patent disputes taking place on related patents in Europe and overseas. If other disputes are taking place, it would be sensible to ensure that your EPO opposition defence strategy is aligned with the strategy taken to defend other related patents. And be conscious of the complicated set of EPO rules that govern opposition and appeal proceedings. There may be EPO Board of Appeal case law which supports your arguments, and this should be used where possible in your defence. It's also important to consider and get an understanding of why you believe your opponent is attacking your patent. Freedom to operate. Your opponent may be wanting to bring to the market a product or process which would infringe your patent, and so knocking out your patent is a way to allow them freedom to operate. Commercial interests. Your opponents may have different commercial interests to you, despite your patent being relevant to their commercial activities. This may leave the door open for an opportunity to reach a mutually favourable commercial settlement. This may be in the form of a license, allowing your opponent to work an invention in their market of interest in return for them withdrawing their opposition against your patent. Is there any possible infringement? So investigate whether your opponent has carried out any activities which may constitute an infringement of your patent. If evidence of infringement is found, this may be used as leverage to support a mutually favourable commercial settlement, especially if the opposition against your patent is not very strong. And some take-home points for defending your patent. So, gather and prepare all supporting evidence as soon as possible. In practice, this almost always takes longer than expected, in particular where it is necessary to obtain experimental data. File a divisional patent application. If the patent is of particular commercial value to you, then it will be sensible to file a precautionary divisional application so that you can pursue alternate claims if necessary. Assess the opposition thoroughly, including an assessment of your opponent's commercial aims, and if there's any means to settle the case by way of a commercial agreement. Ensure your patent application is drafted by an experienced patent attorney, preferably one with experience in handling oppositions. This will ensure that they are aware of the pitfalls of a badly drafted patent application and how this could be detrimental when trying to defend an opposition. And finally, I'm just going to provide some statistics on EPO oppositions. So approximately 1/3 of oppositions result in the European patent being revoked in its entirety. Around 1/3 of oppositions result in the EPO patent being maintained, but in an amended form. And around 1/3 of oppositions result in the EPO patent being maintained as granted. With 2/3 of oppositions resulting in the patent either being revoked or amended, this highlights just how useful EPO oppositions are for opponents to protect their interests in Europe by way of an effective and relatively affordable means. It's interesting to note that only a small percentage of European patents are opposed. Last year, it was between 2 and 3%. About 10 years ago, it was about 5%. So there's a slight decline over the last 10 or so years of the percentage of European patents being opposed. Boards of appeal often set a higher bar to demonstrating an inventive step or that an invention is novel. This means that when an opposition decision which sided with the patent owner is opposed, the statistics tend to change in favour of the opponent, with up to 50% of patents being revoked after an appeal. Success rates of oppositions vary by industry. Sectors such as medical technology or biotechnology often see high revocation or amendment rates and therefore lower rates of patents being maintained as granted. And that's the end of this webinar. My contact details are provided on the screen, and you will all be sent a copy of the webinar together with the recording as well. Please feel free to reach out and contact me with any questions. I'm just going to have a quick look to see if there are any questions that have been submitted. I don't believe there has been. Oh, apologies. Yes, one user has asked, is challenging sufficiency an effective opposition tactic? It's a tactic. Sufficiency or lack of sufficiency is a ground of opposition. However, the rate of patents being revoked on the basis of insufficiency is extremely low. Like I sort of alluded to, you're far more likely to have a patent revoked on the ground of added matter or maybe a clear novelty attack. Insufficiency tends to be a relatively weak attack that's made against a patent. However, that can change before the Board of Appeal. So if you feel like you have a strong sufficiency or lack of sufficiency argument, but the opposition division do not side with you, then there is an argument that you should then appeal the decision because the Board of Appeal may look more favourably on your insufficiency attack. And I do believe that is the only question in the Q&A. Just a couple of questions in the chat function. So what are the advantages to file oppositions earlier? So I believe we touched on that in the talk. Essentially, the later you file, I mean, you could be a bit sneaky and lead the patent owner into a false sense of security, make them believe that there is no opposition to be filed, and then you can hit them with an opposition late on in the opposition period. It also does give you more time to prepare your opposition, and like I said, the time taken to prepare an opposition or defend against an opposition should not be underestimated. So there is an argument that you should use the full opposition period if it's needed. There's a question as well about delaying pending infringement proceedings. This is sort of a case by or national court by national court basis. Some courts will willingly delay national infringement proceedings on the basis of a pending opposition. Other courts find it frustrating how long EPO oppositions take and therefore want to progress their national infringement proceedings. I think that the swing tends to be towards national courts delaying national proceedings in favour of the opposition. But like I said in the talk, recognised by the EPO, and hence why they do try to accelerate EPO opposition proceedings insofar as possible, to basically give something back to the national courts. And I do believe that is all the questions. So yes, I'll end it there, but thank you all for joining. Like I said, if you've got any questions, feel free to reach out to me via the email address, or feel free to give me a call, and hopefully you'll join another Wilson Gunn talk again. Thank you very much.